Hello, my name is Melanie Bradford Holloman. I'm the Executive Director for Alabama Family Trust, located in Birmingham, Alabama. I am also an elder law attorney and have been for the last 15 years. So I'm very pleased today to be able to talk to you about the various long-term care issues that your residents and their families may be facing and some of the strategies that you should be aware of to help guide your residents through this stage of their lives. Now, I want to start by making you consider, why do you really need to understand about long-term care? And the reason that we really want to focus on this is, while you are paid privately, there are no programs that truly help pay for assisted living other than the VA benefit, which we will talk about in a moment. Your residents are at a stage in their lives where they may be with you temporarily. They may not understand all of the options that are available to them. Their families may not understand those options, and that even can hurt you. It certainly can hurt the residents, but it can also hurt facilities when they're not prepared and they don't understand the situation at hand. So we're going to talk about various things that can affect your residents, from the type of estate planning they have to people that might abuse them or financially exploit them. And we'll focus on how to pay for long-term care, because that, from the facility standpoint, is very important. If you can't meet your bottom line, then you can't have residents, you can't host residents. So we're going to talk about all of that. Now first, let's think about who we're actually working with. You're working with the senior person that's in your facility, but you're also working with family members. And you may be working with family members that have just been thrown into this suddenly. They don't know a lot about their parents or their relative situation. They don't know a lot about the legal system and how that should work as it relates to long-term care. So they're grasping at straws. And they could even be doing this as part of the sandwich generation. Now, the sandwich generation are the children that are faced with aging parents on one side and children on the other. They're dealing with two stages of people that need their help desperately, and both of those areas, the aging parents and the children, need different types of care, but both sets are pulling on, they're demanding the parent to help them. So these are very stressed individuals. The children can be very stressed in dealing with this. We're also going to talk about blended family issues. Now, blended families can be a great thing. Many of our families, if not most of our families today, are blended. But they can also have bad aspects as well. There can be blended families where advantage is taken, theft is taken on an unsuspecting senior. So we'll talk about a few things like that that you can be on the lookout for. So when we're talking about long-term care planning questions, we want to think about, has the client or has the resident actually prepared for long-term care? Now, what does that mean? Most people that meet with me will say that they need to do something, but they don't call it a long-term care plan. They don't call it an elder law plan or even an estate plan. They just know that they need to do something. Your families are the same way. Some of them may be sophisticated enough to understand the nuances and to know that they need to have a plan. But even if they have a plan, they may not have an up-to-date plan, and it may not be the correct plan. So we'll talk about some things that go into how that works. But first, do they have a plan? And if they have a plan, is the family aware of it? Does the family know who is in charge if the senior cannot make decisions? Does the family know where assets are? Does the family know about health care wishes? All of these things are extremely important. Now, if the client has not updated their plan in the last several years, that's also very important as well. I've seen plans that were done in the 1990s. The laws were different then. The plans are very vague. They don't take into account any of the changes that have come about since that time, and they really don't do a good job of caring for the senior. In some cases, the old plans are so bad that we really have to go to probate court and work as if we didn't have an estate plan. In other cases, strategies that attorneys could use several years ago, or say in the 90s, don't work now. So you need to update the plans. The resident needs to update the plan to make sure that what they have will actually do what they're needing it to do. Now, of course, we have to look at capacity before we can say if they can update their plan or if they can create a plan. Now, if the resident is in assisted living, I won't get into the medical aspect of being in assisted living or being in memory care, but I think we can all say that individuals in assisted living care are expected to have cognitive abilities. They're not in memory care yet. Now, there may be some situations where that's not the case. So in every situation, you've got to look at the resident to see what that resident's capabilities are. Do they know who their family members are? Do they know what they want to do with their assets? Do they know who they want to put in charge? Capacity has different meanings if you're talking about from a medical standpoint or from a legal standpoint. But from a legal standpoint, the person must be able to know who their family is, who they want to name to be in charge. They have to have some idea of their assets, and for a power of attorney, they have to be able to say, I want you, or Sally or Jane, to be in charge of the assets, to make any business decisions. Now, if there is a question about capacity, then certainly we want to have someone from the medical field make a determination, and also the attorney, because an attorney has to make an observation, an evaluation as to legal capacity when they let someone sign documents. So that is something that should be done. It is true that a family member can obtain a power of attorney and have it signed and have it notarized without having an attorney. They may not even meet with the person. They may use an online program to print out a power of attorney. They may get a form from somewhere else. Now, I think that's a bad idea for a number of reasons. Primarily because you do need an attorney to evaluate the situation. An attorney should not let the person sign if they don't believe that the person has capacity to sign. No attorney wants to go into court someday and be asked, did you think this person had capacity, and have to answer no. That is not a position an attorney would want to be in. An attorney should refuse to let the person sign if they don't think that they have the sufficient capacity. Now, does that mean that the person understands everything that is going on in the world today? No, it does not. It means that they have to understand what they're trying to do, that if it's for a power of attorney, that they're trying to make someone be their agent, be their proxy to handle their business or to handle their healthcare decisions. And if we're talking about a will, then they need to have enough understanding of who their family members are and what their assets are and what they're wanting to do. But do they need to know who the president is? Do they need to know who their state representatives are? Not necessarily. There are plenty of competent people that could not answer that question. So that's not a key to capacity. Now, it could be a clue, but it is not an absolute. So an attorney would be talking with the person. Also, you want to, if you have any question about family members having issues with each other, warring family members that may accuse someone of misusing a power of attorney, then it may be a good idea to have a medical opinion as well. That's not a requirement, but it could be a good idea in some cases. And of course, if someone from the medical profession says that the person is not competent, then that may require a lot more discussion. Maybe we need to have the person evaluated by a neurologist. Maybe we need to do something else, or it may be conclusive that this person doesn't have capacity. Now, I've been talking about a power of attorney, but what is a power of attorney? A power of attorney is a document that is authorized by state law to allow a person to give another person or persons the authority to handle business on his or her behalf. It's that simple. If I give you my power of attorney, then I can make that as broad or as limited as I want to. I can say that you can do any sort of business on my behalf that I can do. Now, state law has changed in the last few years, since 2012, so it doesn't need to be that vague. It needs to be much more specific, or you run the risk of banks and other institutions rejecting your power of attorney. But it's that simple in concept, in that I can say, you have my power of attorney and you can do all these things that I've enumerated, and that means you can do them. It does not mean that you have authority and I no longer have authority. It only means that you can also do things on my behalf. I don't give up any of my control. And that's something that sometimes people get confused with. So the power of attorney has the ability to handle financial matters, but mom and dad, the resident, they still have the authority to revoke that power of attorney at any time, as long as they have capacity. They can name a new agent. They can go conduct their own business that may be totally separate or contrary to what the attorney in fact is doing. Now, the person that's named in the power of attorney is called an agent, or they're called an attorney in fact. Those terms can be interchangeable. But this is a person that in this type of situation with assisted living, that most likely are going to have powers where they can sell property, where they can liquidate assets, where they can pull money from an IRA or other accounts so that they can pay the bills. That's going to be the most logical and certainly appropriate actions that they would be taking. Now, an attorney in fact is not supposed to take assets from the person for his or herself. They're not supposed to gift assets to themselves unless the document says that they have that authority. And most of your powers of attorney don't. And this is where you run into this is where I run into a lot of lawsuits today. I see where people have taken things and they didn't have the authority, and perhaps they took quite a bit, and now they're being sued by other family members for this. It is even a criminal act today. It's a felony if it's over $2,000. If the attorney, in fact, gives himself or herself assets and doesn't have the proper authority to do it. Now, that said, a power of attorney is a very valuable tool. Now, why is this? Why do we care? Well, we care because if the resident does not have a power of attorney, then we have to go to guardianship and conservatorship. Now, guardianship is going to be more about taking care of the person. So this is more of your health care directives. I like to separate them into a financial power of attorney and a healthcare power of attorney. Some attorneys have them where they're in one document, or they'll have a healthcare directive. But a legal guardian is the person that makes decisions about whether or not the person would be in assisted living. Are they getting good care? Do we hire this caregiver? Do we get rid of this caregiver because they're not taking care of the person properly? That is the kind of decisions that a legal guardian would make. Now, a conservator is going to pay the bills. The conservator is going to handle the accounts. They're going to make sure all of the finances are in order. They're going to be the ones taking money out of the IRA or doing whatever needs to be done in that sense. Now, if you do not have a power of attorney that can handle these situations, you must go to probate court. And I see a lot of this, and particularly today when we have COVID, that is disastrous for a resident because the courts are behind. The courts are always usually a little bit behind. And notice and deadlines that are built into the law can make court matters take more time. COVID makes it much worse. So now we have a situation where people may realize all of a sudden no one is in charge, no one has power of attorney to handle matters on behalf of the person that has lost capacity. Let's say they've had a stroke suddenly. So this happened suddenly. They were fine last week, but now they're not fine. What do we do? How do we pay bills? How do we handle things? Well, at that point, you're looking at court action. And the only way to get in control of these things is to go to the probate court where the person is a resident and to ask that court to make a person, usually a family member, the conservator so that that person can handle all financial matters. Now, if there's not a family member or there's not a good family member that's available, it may be a local lawyer that is named, it may be a county conservator, or it could even be a volunteer, such as a family or a non-family member that wants to serve. Being a conservator takes time to get the court to approve the process. And then the conservator has to constantly go to court and ask for permission to be able to do things. Now that can be a good thing if we don't have good family members that we can pick from that will do the right thing. That's much better to go through the court system and have delays and red tape than to name a power of attorney with someone that might actually take money inappropriately. But if we have good family members, then you want a power of attorney in place rather than going the conservatorship route. For one, if we don't have a way to pay bills, if we don't have anyone else that is on the person's account or any other access to funds, that means your facility may not be paid until a conservatorship is in place, because no one can sign a check, no one can withdraw funds. So it can be very important to you, as well as the family and the senior, to have a good power of attorney in place. Now, the guardianship, as I mentioned just a moment ago, is for health care. So you may have one person that is conservator, you may have a totally different family member that serves as the guardian, or it can be the same person. But if you do not have, if the resident does not have someone named in a power of attorney, then probate court is where the family must go if the senior loses the ability to make his or her own decisions. Now, I'm not going to go into last will and testaments. I'm not going to go into trust that much, because that really is estate planning that is getting into privacy issues with the senior, and I don't expect that you probably talk to them to that degree. However, I do want to start talking about the different ways to pay for assisted living and to pay for any other stages of long-term care that the resident may have. And the family will be asking you these questions. The residents will ask you these questions. I go to these facilities and talk, or at least I was able to before COVID, and I know that the residents ask about these things. So one of the first things we're going to talk about is something that helps the assisted living facility specifically, and that is VA aid and attendance. Now, this is a benefit that many of the seniors may not realize is available to them. They may not realize it exists. Only about 5% of seniors in the country get this benefit, so that's very few. They may know about it, but they may not think that it applies to them for a couple of reasons. They may have been told several years ago, oh, you have too many assets, oh, your income's too high, you just don't qualify. And so they said, okay, and they never looked into it again. Now, if they were given that kind of answer before, what could change to make them eligible now? Well, a couple of things can change. One, the law changed in 2018. Now, there are some good things about that, and there are some things that are not so great. But the good thing is that a resident can have more assets than they could before and qualify. So that is something that works to the resident's advantage. The VA changes to the law also give us more guidance on what we can do. There are things that can be done as far as trust, which I won't get into again in depth, but you can use trust to properly and legitimately help a senior qualify for VA benefits. It takes time to do it. The rules have now changed from where it could be immediate to where it now takes 3 years for that to work, and it has to be done correctly. And that's not something that your VA reps will help you with. They are strictly going to look at the bottom line assets and the bottom line income, and it either fits in the box or it doesn't. They are not, they're not advocating for you. They're working for the VA to help, but they're not advocates the same way that a VA attorney is. A VA attorney can help the senior actually qualify. That can be done through making sure that the assets are structured properly. It may or may not include using a trust. It's going to include having a good knowledge of how to properly do the paperwork so that things even like independent living can qualify. I routinely hear assisted living, let me say it this way, I routinely hear people say that independent living does not qualify now for VA aid and attendance. That is not true. It is true depending on how the paperwork is written up. And if it is written up properly, it can still work. And we see it work all the time. And we're not, I mean, it's disclosing it's an independent living situation. So there's no smoke and mirrors. It's just about the way it's presented. So the only purpose of my saying that is your residents, if they can take advantage of the VA aid and attendance, which either their spouse or they themselves earned, can qualify for this and have help staying in assisted living. Because we all know what's going to happen. If the resident runs out of money and they don't have something like VA aid and attendance to help them stretch out their money a little longer, they are going to go to skilled nursing care. They're going to go to a place where Medicaid can kick in because there's no other option for them. VA aid and attendance can help them age in place at your facility. So it's very important that it be done correctly and it be evaluated correctly. Now, just quickly giving you just the overview of VA aid and attendance, because I'm sure that you know how the benefit works as far as the basic structure. VA aid and attendance is not a pension. I mean, it is a pension benefit. It is not a service-connected disability rating. So it is totally separate of being disabled. The veteran does not have to be disabled to receive this benefit. Now, the veteran has to have disability as far as medical conditions currently, meaning that they need some care, but it does not have to be medical conditions related to service. There are income and asset requirements. This is based on need, but again, we can help with that. And the benefit for a wartime veteran is over $1,900 a year. Now that's tax-free money. Now, if we have a couple, it's going to be over $2,200 a year, tax-free. And if we have a single surviving spouse, it's going to be over $1,200 a year, tax-free. That's a lot of money that can be used each month to pay an assisted living bill and help stretch out that senior resident's assets for a much longer time. In some cases, it means that the senior and or the spouse can stay in assisted living and or memory care for life. They may not ever have to go to a nursing home simply because of this benefit. Now, if they do go to a nursing home later and they receive Medicaid, the benefit's reduced to $90 a month. That's not great, but that's still $90 a month that the senior gets to keep to use for his or her needs. Medicaid would pay the nursing home bill. Now, for VA aid and attendance, there is a wartime service requirement, and this gets people You either fit in this or you don't, and there's not any wiggle room. There's no gray area for this. It's a 90 days or more of service. 1 day has to be during a period of war, and I'll explain that in just a minute. It must be an honorable discharge or a general discharge. There must be some medical criteria, which I will get to in just a moment, and then I'll also talk about the income and asset limits. But the wartime service is a very hard, fast rule. You must fit within, of course, for World War I, that's not really an issue anymore. But for World War II, we are seeing we still have our World War II veterans, and they had to serve between December the 7th of 1941 and December the 31st of 1946. So they had to serve during that period. They only had to serve for 1 day during that period. The other days could be served outside of a period of war, but 1 day has to be within that. For the Korean War, it's June the 27th, 1950 through January the 31st of 1955. And that's hard and fast. Again, only 1 day has to be served during that time, but at least 1 day has to be served during that time of war. For Vietnam, it's much more difficult. From August the 5th of 1964 through May the 7th of 1975, you had to serve during that period of time 1 day. But there were a lot of veterans who served before then, and they considered it Vietnam because a lot was going on before Congress officially declared war. So for those veterans, and this can have very harsh results for some of these veterans, February the 21st, 1961 through August the 5th of 1964, they had to be boots on the ground in Vietnam. So for these other time periods, you could be in Georgia, you could be in Kentucky, you could be anywhere in the United States, anywhere in the world. You didn't actually have to be in the theater of war for that 1 day that you served. But for this specific period during Vietnam, you actually have to be boots on the ground. So that has harsh consequences for some of our seniors. Now for the Persian Gulf War, it's August the 2nd, 1990 through the present. We are still in time of war. Now for medical criteria, if someone is over the age of 65, they're going to be considered 100% disabled if they need assistance with 2 or more activities of daily living. I know that you know what activities of daily living are. You know, you're eating, you're dressing, you're toileting, you're walking, you're showering, hygiene. So those are the activities where we must have someone assisting the person. Now, they may also be bedridden, and if that's the case, then certainly they make the criteria. Or if they're blind or basically blind, they're going to meet the criteria. Now, I know at your facilities, they have to be somewhat independent to be able to be there. But what we're saying is they need assistance. And I know that you do assist with these activities of daily living. So that's where we have to present it the right way to the VA that you are doing these things for the person, or that a sitter is coming into the facility and doing those things. Now, remember, the rules changed in 2018. So the old rule where a resident could transfer everything they owned and suddenly qualify for VA aid and attendance the next day is gone. Residents cannot do that any longer. They have to pre-plan, and the pre-planning takes about 3 years. Now, there are things that we can do because the asset limit has been raised. It may not mean that the resident has to wait 3 years. It all depends on what the assets are, how much and what they are. But it's very important for your residents to know about this benefit because it could keep them in your facility. And of course, important to you, make sure you're paid for what you're doing. All right, now we're also going to talk about nursing home care because in addition to people being in assisted living and memory care in your facilities, because what I have been talking about with assisted living carries over to memory care, and many of you have memory care with your facility, but some of you may actually have skilled nursing care also associated with your facility. And for those of you that don't, I hope that you want to help your residents transfer to skilled nursing care when it's necessary in a way that will best benefit them. So that's what this talk is that's what I'm about to cover right now. Because if you don't help the family get on track, if you don't give them guidance along this way, then many things can go wrong, many things that are disastrous to them. So we're going to talk about how this works also. So you already know that many of our seniors they need assisted living, they need memory care, or they need skilled nursing care. Our family dynamic is not what it was in the past. You know, this isn't the Waltons where grandma and grandpa stay with the children and the grandchildren and grow old and pass away at the home. Now, that is true in some families, but more and more the sandwich members are working. They're trying to take care of children, work a job, and take care of the seniors, and these seniors may not be able to stay at the home. They may need their own caregiving. So more and more families are not able to care for people at home. They're going to assisted living, but then when they reach the point that they can't be there, and maybe they don't qualify for memory care, they must go to skilled nursing care. So, especially with Alzheimer's today, this is happening more and more. It's only expected to rise. And because the cost of nursing home care is around $7,000 a month, even in our rural areas in Alabama, it's very important that these families understand their options and how things work, because even people with sizable assets can be broke, can go broke very quickly, paying $7,000 or more a month. Now, the types of care, and I imagine that you know this, but this is just a refresher. The types of care, types of payment for long-term care are Medicare, private pay, long-term care insurance, VA aid and attendance, which we just talked about, VA nursing home, and then the last stop is Medicaid. And that's really all there is. And most of your families don't realize that if they run out of money, they may not qualify for these programs. Most families think that if mom and dad simply run out of money, that the government will pay for it. And they don't realize that there are rules, and that if they mess up, Medicaid may not pay for their care. So just quickly, a refresher for you, because we're going to move on to some subjects that we'll talk about more in depth. Medicare is only going to pay for up to 100 days. So if mom falls and breaks her hip and she goes to rehab after her hospital stay, then most of your Medicare plans will pay for the first 20 days for therapy. Now, if they're sent to the nursing home and it becomes obvious that rehab is not possible, Medicare will stop paying. But as long as rehab is possible, Medicare will pay for up to 20 days. And depending on the senior resident's type of Medicare supplement, they may have a supplement that will pay for up to 100 days, meaning the supplement will pay for their copay. But after that, Medicare does not pay. So Medicare is not an option for residents, and you probably would be surprised at the number of families who do not realize that Medicare will not pay for nursing home. Now, long-term care insurance is also very important. Long-term care insurance can be the solution if the senior has it. Most of our seniors don't have it, so it's not something that we can rely on. But when they do, we can combine it with their Medicare, we can combine it with their income and their savings, and we may have a number of years that their care is covered before we ever need to think about Medicaid. But that, again, is if they have it. If they don't have long-term care insurance and they can't combine any of these other methods, they're left with private pay. And private pay is just what it sounds like. And of course, you know this, they're paying for it out of pocket. They're paying for it with their income, with their account balances and their checking and savings. They're cashing out CDs, they're draining IRAs, they're selling extra property. It's coming from everything. And they will do that until they become eligible for Medicaid. Now, when the senior has to go to a nursing home situation, the only options are an actual private nursing home or a VA nursing home. Now, if the senior is fortunate and is a veteran, then the veteran can get on the waiting list with the VA nursing homes. We've got 4 really good ones in the state of Alabama. We have one in Huntsville, we have one in Alexander City, we have one in Bay Minette, and we have one in Pell City. But there are waiting periods for these. But once the senior is able to go to the facility, the amount the senior pays is very minimal. And this can be the solution, it can be the answer for families with a veteran. Because you're looking at, let's say that mom and dad are at home and now dad has to go to a nursing home and maybe mom is going to go to assisted living. If dad can go to the VA nursing home and his care, and it depends on which facility he goes to, but his care only costs between $400 and $800 a month, then the rest of their income, particularly if he's getting VA aid and attendance, can be used for mom for her assisted living, or if she is at home to pay for caregivers at home or just her daily cost of living. So it can be a wonderful solution, but that's only if they're eligible and they get on the list and can wait until they have a spot. Now, if they have to go to Medicaid just to a private nursing home, then Also, you've got to look and see if a bed is available. You may have to get on a waiting list, but particularly if you're not looking in the big city, because I do know that there are more limited beds there, it's usually fairly easy to find a bed. But now you have to look at how are we going to pay for this. Now, families will do all sorts of creative things. Most of these things are a disaster. Most of these things don't work. And they just don't understand that they have done something that will actually cause more problems in the long run. So I know even though you're at an assisted living facility, you've heard of these things. You know, taking everything out of one spouse's name and putting it in the other spouse's name doesn't work. It doesn't help at all when you're dealing with Medicaid. Taking everything and putting it in a safe deposit box doesn't work if you are honest on the Medicaid application and don't commit perjury, because they're going to know. Moving it to or putting a child's name on all of the accounts doesn't work. Just saying that this is my IRA, you know, he's my husband, it's not his IRA, he's not on it, that doesn't work. All of the schemes or ideas that people often have to try to shelter money when it comes to Medicaid usually don't work. But there are some methods that will work, and that's what I'm going to talk about. And one of the biggest things is Alabama Family Trust. You can help your residents save a fortune and help protect their spouses if they still have a living spouse, and also help the children who are trying to manage all of this if you can direct families and let them know that they should be looking into this. So, you know the requirements for Alabama Medicaid. I'm not going to go into that. And income requirements, that's something that's easily fixed if someone is over the cap. So I'm not going to deal with that. We'll just skip over that. But resources are the big issue. Resources are where people get in trouble. And this is because they know that assets must be spent down. The resident is only allowed to have up to $2,000 in countable assets to qualify for Medicaid. And this is where the couples come up with all sorts of ideas, or the children come up with all sorts of ideas to try to protect property. The reason most of these schemes will not work, if there is a couple, then Medicaid is going to look at all assets, no matter how the asset is titled, that belong to either one of the spouses. And they're going to total that together, and they're going to call that a snapshot. And the snapshot gives them the number that they need to plug in their formula to decide how much the spouse that stays at home can keep and how much the spouse in the institution must spend before Medicaid will pay. Now, what actually happens is the Medicaid will take the total, they will divide it by 2, and they will say that the spouse that stays at home can keep up to half as long as it does not go over $128,640. So if half goes over that, then the most that that spouse can keep is the $128,640. The rest of that would have to be spent on the spouse in the nursing home's care before Medicaid will pay, and that's called a spend down. So this can have very harsh results. particularly if you have a situation such as a blended family where maybe the spouse is recently married. Maybe they were married 2 years ago and one spouse was had very modest assets and the other spouse had fairly significant assets. This is common. Now, I can tell you what those spouses thought when they married or what they generally say they thought. The idea is their estate plan probably even says, well, you know, my wife can have this account. If when I die, she can stay in the house for life, but everything else will go to my kids, or vice versa. And basically their estate plans are saying that their children will get what each spouse brought into the marriage, and they're not taking away from each other. Well, that's great if their estate plans control. But this is one of those blended family issues I mentioned. If Medicaid gets involved, if the nursing home gets involved, then it doesn't work that way because Medicaid does not care what their will says. Medicare doesn't care what their revocable living trust says. Medicaid doesn't even care what the prenup says. They are going to look at the total amount of assets, no matter who owns the asset, and they're going to divide it, and they're going to use that formula and say that X amount of assets must be spent before the spouse can receive Medicaid. Now, what happens? What happens in the scenario I just talked about a moment ago? Well, in Alabama, you know, there's not a lot of options. There are some things that can be done in other states that we cannot do here. So be careful about Googling because you can do some things, you can try to do some things that will not work in Alabama. One of the things that will work, of course, is a divorce, especially if there's a prenup involved. Because the prenup will work if the couple actually gets a divorce. It doesn't work if they don't get the divorce. So that can work. But a divorce will not work if you try to say without a prenup that everything just goes to this spouse and nothing goes to this one. Now, in the case of the scenario I gave you a moment ago where they had only been married for 2 years, it might work. But if they've been married for 30 years, that's not going to work. Medicaid is going to want to know that it was equitably divided. Now, equitably does not mean equal, although that is usually what the court is striving to do. So it depends on the circumstances of the couple and the assets as to how divorce would work. But that is an option. Another option is something I'm going to talk about in a few minutes, which is using Alabama Family Trust, because it can be a very effective tool in making everything work. Now, spend down is a situation where you're doing what I said a moment ago, you're spending everything so this spouse can receive Medicaid. And I'll let you look at the example that I have here because we need to move on to make sure we can cover everything. So a couple of examples. One thing that we always have that comes into play, like I talked about a moment ago, is some of the penalty issues that can come into existence. So we may have a situation where, like I talked about a moment ago, one spouse has brought significantly more assets to the table, and it's really not fair that that spouse could lose everything because the relatively new spouse is now going into a nursing home. Now you can look at it different ways, but most people will say it's relatively not fair, and I can promise you that spouse's children are going to say it's not fair. So That is one issue. Another issue is when someone goes into the nursing home and Medicaid starts its audit, which is a look back over the past 5 years to see how the resident spent his or her money. And they start finding out that children used a power of attorney to take assets, give it to themselves, or the child just actually had access to a debit card or some other way and literally stole money, or the resident even gave money. You know, the resident may have said, I want to give my granddaughter $20,000 for college. It can be something that the resident fully intended to do, not to defraud Medicaid, but because she had helped all of her other grandchildren. But this grandchild's gift fell within the 5 years. Anything like that, any kind of gift, is going to trigger a penalty with Medicaid. Now, what does penalty mean? A penalty simply means that Medicaid says they are not going to pay the resident's nursing home care until that amount of money can be somehow gotten back, or someone pays the nursing home for the number of months that would be the equivalent of that money. So you've either got to give back the money and spend it, or someone's got to pay the nursing home during the penalty period, and then Medicaid will start paying. Now, the danger is that usually people have spent all of the money before they apply for Medicaid, so there is no money to pay through the penalty period. That means that the nursing home has to either eat the amount of months that the person is penalized, or there's some good angel in the family, some good child that's going to step up to the plate and pay for, you know, what the bad child might have stolen, or whatever the case, someone will have to pay it. So those are your two big issues. And then also the issue of we don't really want to spend down all of the money that Medicaid would say that the institutionalized spouse has to spend. The reason for that is if you spend it all and you have a spouse that is still at home, what is going to happen is that the money that the spouse at home is allowed to keep for his or her care, they're going to end up spending from that to buy all of the things that are needed for the institutionalized spouse that Medicaid doesn't cover. Because I can tell you the $30 a month allowance that Medicaid allows is not going to cover everything that that spouse will need. So those are three big issues that need a solution if you're getting into the nursing home situation, you're looking at Medicaid. So this is where Alabama Family Trust comes to the rescue. And I'm going to be telling you about how it can work and how it can work for your residents when they're starting to face this situation. And of course, Alabama Family Trust can also be used for your residents. There's nothing that would prevent them from having an Alabama Family Trust, but most likely you are going to see this used as they're starting to go into the nursing home. So what is Alabama Family Trust? Well, it is a 501c3 nonprofit company. It's a pooled trust company that was created by the state of Alabama in 1994 for the very purpose of sheltering assets. So this isn't some sort of scheme. It was authorized by federal law. Federal law first created the idea of a special needs trust and said that a person could do this, a disabled person. And Alabama law enabled it in Alabama and created Alabama Family Trust. Now, the idea is that the trust is a nonprofit way for someone that is disabled to be able to invest usually a small amount of money, although it could be $1 million or $2 million or any amount. But it is a way for a disabled person to invest their money and have quality management, the same kind of management that you would have at a big trust company, but not have to pay huge investment fees. And also, because most of your big trust companies will not take an account if it's under $500,000. Well, there are plenty of people out here going into nursing homes that have $150,000, or they have $80,000, or they even have $30,000 that has to be spent down before they can get on Medicaid, but they would be benefited by having a trust so they didn't have to spend it down. So Alabama Family Trust was created to provide this. The very function of the trust is to hold the spend down assets, which that just means the assets that would make the person ineligible. So if Medicaid says that dad who's in the nursing home has to spend $50,000 before he's eligible for Medicaid, then placing that money in Alabama Family Trust is a way to shelter that money so that Medicaid has to pretend it doesn't exist for purposes of eligibility. He could then apply for Medicaid instead of spending it all down and have the money in trust to supplement his needs. Now, that provides several purposes, several back purposes. You know, the first purpose is it can provide things he needs. I mean, above that $30 that Medicaid lets him keep. So if he wants a TV in his room, if he wants a cell phone, if he wants a sitter, if he wants to upgrade to a private room, anything that you can imagine, you know, he's lost his dentures, he needs new hearing aids, anything that is for his benefit that you could imagine that Medicaid won't pay for, that trust can be used to pay for those needs. And that means that his family doesn't have to pay for it out of their pocket, because, you know, some children are not financially where they can pay for things easily. It means that the spouse, if there is a spouse, doesn't have to pay for it out of his or her remaining assets, because at this point they don't have a lot of assets. So they need to preserve those assets. So that's a huge benefit, huge, huge benefit. It also means that penalties can be dealt with. It can work to protect that blended family situation. It can work to help with that situation so that everything does not have to be given to Medicaid. So it is a very valuable tool. It was set up by the state of Alabama to do that. Now, what is the Special Needs Trust? It can be used for any disabled person, any age. Now, we're focusing on seniors because we're talking about assisted living and nursing homes, but it can be used for any age group. The disabled person, it's easy to meet that requirement. They do not need Social Security to say they're disabled. If they're 65 or older and they meet the criteria to get into a nursing home, they're disabled. End of story, easy to prove. Now, the assets, as I said before, are sheltered. They are not something that Medicaid can even consider. Now, Medicaid will know that assets exist. It's not a secret. but they are told by law that they have to ignore those assets for eligibility purposes. So you're sheltering, but Medicaid knows you're sheltering. Now, I just told you a moment ago some of the things that a trust can pay for, but it really can be far more than anything, any list I can give you today. There are some examples on the Alabama Family Trust website, but it really can be for anything you can think of. It can be for therapy. If home health says that the person, Medicare is not going to pay for therapy anymore, but the family feels like therapy is beneficial for the resident, it can pay for therapy. It can do anything really as long as it is for the needs of that senior. Now, it cannot make gifts to family members. It's got to be for the senior. But it can do basically anything to supplement that senior's standard of living, to make their life better. As I said just a moment ago, this means that the children do not have to pay out of pocket to try to do things for their parent. It means the spouse doesn't have to pay out of pocket. It means the disabled person is able to spend their own money for their own needs and not have to just exhaust everything. If they have capacity, mental capacity, then they know they've got some dignity, that they still have some assets that can provide for themselves. It means for a nursing home, it means that they get paid. So why do I say that? Because it can pay for penalties. So remember a moment ago when I said that grandmother gave away $20,000 to the granddaughter, and we said that that would cause a penalty. If, let's say there's $50,000 in AFT, then when that penalty is assessed, the family can go to Alabama Family Trust and ask the trust to pay the nursing home for the months during the penalty period. Now, remember what we said before. Before, grandmother would be broke before we ever knew that there was a penalty that would be imposed. There's not any money to pay that belongs to grandmother. The family may or may not have the money. And of course, the nursing home does not want to eat any unpaid months. They don't want to have to write off any months. So let's say that grandmother had $50,000 leaving the assisted living facility and put it in Alabama Family Trust, applied for Medicaid, and then found out, oh, that $20,000 has gotten me in trouble. They assessed a penalty. Well, now everything's okay. Everyone's going to turn out great in this scenario because the family just has to ask the trust to pay the $20,000 to the nursing home. You're just going to pay those many months. And then Medicaid's going to start paying. You still have roughly $30,000 in trust that can be used for grandmother, and everyone is in good shape. So it's very beneficial for the facility to do this also. It's dangerous when facilities just say, spend all your money until you get down to $2,000 and then let us apply for Medicaid. That's dangerous because this very type of thing can happen. It's much better if there's money left when the person has to leave your facility to go to the nursing home to set up an Alabama Family Trust. So one, they have extra money to use for themselves, his or herself. And two, if there's penalties, they can hopefully pay for all of the penalty. But even if it exhausts everything in trust, at least you were able to pay part of the penalty period, which is going to at least make it better on everyone else. So very huge that this can help. Let me go down to, we're almost out of time, so let me move down just a little further. So one of the benefits of Alabama Family Trust is that it will accept trusts as small as $1,500. Again, your big trust companies will not talk to you if it's not roughly $500,000. But for someone going into a nursing home, you know, $30,000 would have been a lot of money for that grandmother with the potential penalty issue. $25,000 would have gotten her out of the penalty issue. So having a trust is very beneficial. You've got to find someone that will take it. Alabama Family Trust will take a trust as low as $1,500. The trust assets are going to be pooled for investment purposes, and that just means to try to bring a bigger return to the senior's account, but they're separate individual accounts. There's a $750 setup fee, but that is very, very low compared to any other trust nationwide that I'm aware of. And Alabama Family Trust does not charge administrative fees for trusts with balances under $3,000. Now, they do charge administrative fees for trusts over $3,000, and that fee is 1.6% per year, only on the interest earned. So what that means is instead of charging a flat 1.6% on the entire trust corpus, the whole principal and interest earned, they're only charging it on the interest earned, the growth during that year. That is about as non-profit as it gets. And to this day, I've not heard of a trust that charges that low or lower than that. So it's a very, very good value for people. Now, the money is managed with Warren Averett, which is a substantial wealth investment company. They have offices throughout the Southeast, and they provide wealth management. So the families that set up a trust with Alabama Family Trust are able to talk to an actual financial advisor. They're able to pick from a series of investment options. They're not locked into that option. They can mix it up. If they want to have it invested one way this month, and then 3 months from now, they decide they want to change to, say, a more conservative approach, they can do that. The money's managed by them, so you have that expertise in the money management, and it's not controlled by Alabama Family Trust. The family does not give up control on how the money is invested. Now, the family does give up some control, though. The trust must be irrevocable to do this. The government, when they set this up, when the state of Alabama and federal law created this, they said that the trust has to be irrevocable. So when the senior creates this, they cannot change their minds later and revoke it. If a family member using a power of attorney creates this, their power of attorney has to have the authority to create it. It's necessary that they have the actual authority to create an irrevocable trust document. Not all powers of attorney do that. So you have to really be careful and look at your power of attorney. But the trust document must be irrevocable. The government says if it's not irrevocable, then it's still your money, and so they will count it. So it's not sheltered unless it's irrevocable. Once it's irrevocable and invested with Alabama Family Trust, Alabama Family Trust works with the family. The family will ask and say, you know, mom or dad need such and such. Mom or dad need, you know, this bill paid or that bill paid. The trust has a board made up of 11 board members. Most of them are estate planning attorneys, and all of them have been selected and confirmed by the Alabama Senate to sit on the board. They do this for no payment. It's not a paid position. They do it because they believe in the cause and they want to help people. And their job is to look at the disbursement request and decide if a disbursement is going to be against the criteria for keeping Medicaid benefits or not. If it's not against Medicaid criteria, then they should approve it. And if it is something, for example, giving a gift to a child, then they will have to veto it because they know that that would cause Medicaid to revoke Medicaid benefits when Medicaid finds out about it. Now, that is how Alabama Family Trust works with the family. Alabama Family Trust also has a case management aspect. And this is something that Alabama Family Trust is very proud of. It's new. Alabama Family Trust has well, let me say this, that when the senior passes, and I'm saying this premature for my slides, but when the senior passes, Medicaid has to be reimbursed to the extent possible. Now, if the trust has been exhausted, then Medicaid gets nothing. If the trust has, you know, $5,000 in it, then Medicaid can only be paid to that extent. But before Medicaid gets anything, Alabama Family Trust is allowed to keep 10% by statute, by state law. That money goes into a charitable fund. The charitable fund, the Alabama Family Trust Board has decided that they are going to use some of that charitable money to benefit any new trust beneficiaries. So if a senior opens a trust with Alabama Family Trust, they have the option to ask for case management assessment. And this is going to be a professional that is going to come in and a social worker and do case management. They're, you know, if it's a nursing home situation, I don't expect they'll spend much time on saying whether or not they're in the right facility, because hopefully that's going to be a given. But they will spend more time on looking at what other kind of benefits are available. Are they on the best insurance plan, best supplement plan, best drug plan? Are there any issues that are identified that they can help with? Do we have any family members that don't understand how things work? Maybe they need some coaching, some counseling. So that's something that can be provided free of charge to the residents. Now that's the assessment. So implementation is going to be based on what the recommendations are. But this is a fairly lengthy assessment that is provided free of charge. So it's a huge benefit for our new beneficiaries, and I hope that families will take advantage of this, but it is optional. Now, to establish a trust, it's fairly easy. The documents are on our website. All of the forms are there. They're fill in the blank. They're fillable PDFs. It doesn't take a lot of information to fill out the documents. It can be done very quickly. The biggest hurdle is going to be having the assets in a form where you can send the funds to the trust, and making sure that either the resident can sign the trust documents or you have a power of attorney that gives the authority to sign the trust documents. or you have a legal guardian or conservator that directs the establishment of a trust, or the court itself establishes the trust. Typically the senior signs the documents, or we have a power of attorney agent that signs the documents. Again, it's very easy. You don't have to have an attorney. Now, Alabama Family Trust cannot provide the family with advice on their Medicaid application. If they need that kind of help, they must or they should talk with an elder law attorney. But Alabama Family Trust will talk and walk the family through every step of filling out the paperwork for Alabama Family Trust. And there are a lot of resources on our website that can help the family. Now, how does it work? Well, the family, and one person is going to be called the representative. That representative is going to submit a disbursement request to Alabama Family Trust and is going to ask for the funds to be expended a certain way. It may be, please pay, we have a prepaid contract, please pay this contract for funeral expenses. Alabama Family Trust, the board, is going to review the contract, make sure that it is in the right format that it needs to be in to work for Medicaid purposes, and then they would approve it. Now, in that case, Alabama Family Trust would pay directly to the funeral home for that. Now, in some cases, it may be something where the family representative could use a programmable debit card. Now, we give debit cards to the family representative, but they don't work unless Alabama Family Trust programs it. That is a requirement so that it cannot be said that the beneficiary has access to money. They will let this work this way as long as we control their debit card. So if we know that the representative is going to buy a lift chair, or going to buy clothing or toiletry items or whatever it is, then we can program the card so they can use the debit card. Conversely, if the representative buys something himself or herself, they can send in the receipts and a request for disbursement, and the trust can pay them directly, reimburse them. Alabama Family Trust also has a charitable fund. So if the person runs out of money or they don't have enough money in their account, then they can ask the charitable trust to pay for something. We have people that will ask for the trust to pay the private room difference so they can be in a private room. So that's possible. Again, that is the money that we're allowed to keep instead of paying Medicaid, and we're using it to benefit the beneficiaries. We're able to help them. Now, what happens when the person dies? Federal law requires that, and Alabama law require that Medicaid has to be reimbursed. And of course, I've told you that 10% is kept. The remaining money is used to reimburse Medicaid. If Medicaid is reimbursed and there's still money left in the trust, then that money can go to the family members or whoever the resident listed on the trust documents. So it's possible that the family might get money, but that depends on how long the senior lives and how big the trust is. So I hope that in looking at everything, you will think about Alabama Family Trust when you're talking with residents, when you're talking with them when they first come into your assisted living facility, because pre-planning is the best kind of planning. That's going to ensure that they can stay with you the longest and that they can then transfer to a facility later if needed and actually make their money work to their best benefit. It's also going to keep their families from being left unprepared by not having good powers of attorney, by not having pre-planned, or by, doing things that they thought might shelter money, which will not work, or that they somehow unknowingly cause penalties. So to the extent that you're talking to your residents when they're coming into the facilities, that you're talking with them during any kind of programming that you have, be mindful of all of this, because it can truly, truly benefit your residents and give them a better quality of life, help their families, and even help your facilities to do better. If you have any questions, feel free to contact Alabama Family Trust. We will be happy to talk with you. I have our contact information on the slides and the names of all of our key staff officers. So feel free to contact us at any time. It has been a pleasure to talk with you today, and I look forward to talking with you in person in the future soon. Thank you.